Hello, everyone. Our next presentation to celebrate VGA's 6th birthday is Bryna O'Sullivan, and she is going to be talking about an establishment church. What's that?
Okay, let's get started. So, one of the misconceptions we have about US history has a lot to do with freedom of religion. Now, the term establishment comes into play actually in the First Amendment, particularly the Establishment Clause, which says Congress shall make no law respecting an establishment of religion. This is where our idea of freedom of religion being central to the US and the US's existence comes from. But the idea pretty much entirely dates to the mid 1700s, the era of the American Revolution. Prior to that, many colonial governments had laws dictating which churches would be supported by the state and even where their their citizens would attend church. In colonial America, the established or state church was very much a part of American life. So what's the official definition of an established church? Oxford Reference defines an established or state church as a church the government recognizes as having a unique or superior claim to the allegiance of the population in religious matters. A little bit vague, but it comes into play in our genealogy. So, what churches were established? We actually had a few different options for established churches. The Church of England was established by law in Maryland, Virginia, North Carolina, South Carolina, Georgia, and parts of New York. The Congregational Church became the establishment church somewhat by default in Massachusetts, Connecticut, New Hampshire, and Vermont. The towns were allowed to select the minister, and because most people were Congregationalist, the minister was generally Congregationalist as well. What are the implications to having an established church in the colonial period? Well, often there was required attendance and there were penalties for failing to attend. The church might be a legal recorder of births, deaths, or marriages. You'll see how that comes into play in Connecticut, where I'm from. There was often taxation specifically in support in the church. And if you wanted to attend another church, you had to file paperwork with the town, the county, or the state. Now, the specific laws are going to depend a lot on the time period and the location. How do you find those specific laws? Look for legislation that was produced by the colonial government where your ancestor lived. In most cases, these statutes have been printed and are available online. For example, Henning Statutes at Large, which document the colonial statutes of Virginia, are available in Family Search. If you are struggling to find the documents in question, the state's library or archives can typically direct you to the appropriate publication. And let's see how this plays out. I'm using Connecticut as an example because that's actually where I'm from. And this is one of the biggest things that people miss when they're doing Connecticut research. The established church in Connecticut was crucially important to colonial governance, and learning about its records can help you fill in significant gaps in your family tree. Now, Connecticut's colonial statutes have been made available through the website of the Connecticut State Library. To find the statutes in effect during your ancestor's life, you will have to look at the specific volume for the appropriate time period. Those volumes, thankfully, are digitized and are available. So to find them, you can go to ctstatelibrary.org. Under audience links on the main on the main page, click on Legal Researchers. And on the next page, click on Connecticut Statutes and Acts. So go to ctstatelibrary.org. Under audience links, click on Legal Researchers, and then on the next page, click on Connecticut Statutes and Acts. On the next page, click on CT Statutes Revisions 1650 to 1958 and choose the volume that covers the appropriate period. So let's talk through some of the examples of the laws governing the churches of colonial Connecticut. We're going to start with the 17th century because that's the earliest laws in effect, and you'll see kind of the extreme version of the establishment church in place. So this is the earliest law that I was able to find, which is included in the public records of the colony of Connecticut prior to the union with New Haven Colony in May 1665. And it indicates that the general court, which is the kind of state government in the colonial period, controls the establishment of churches. This court orders that there shall be no ministry or church administration entertained or attended by the inhabitants of any plantation in this colony, distinct and separate from, and in opposition to, that which is openly and publicly observed and dispensed by the settled and approved minister of this place, except it be by appropriation of the general court and neighbor churches, provided always that this order shall not hinder any private meetings of godly persons to attend any duties that that Christianity or religion calls for, as fasts or conferences, etc., etc. So the short version, under this law, the general court set up churches, and if you wanted another church, you had to have permission of the general court and the neighboring churches. Think about how that played out about your access to religion. If you lived 15 miles from the church, you still needed permission to set up a new one. In the same volume, you'll also find that there was required church attendance on Sundays, public feast days, and days of Thanksgiving. And if you did not show up, there was a penalty. And if any person within this jurisdiction shall, without just and necessary cause, withdraw himself from hearing the public ministry of the word, after due means of conviction used, he shall forfeit for his absence from every such public meeting 5 shillings, all such offenses to be heard and determined by any one magistrate or more from time to time. So think about it this way. You skip church on Sunday, you don't have a good reason for doing it, you can end up with a court case. And finally, you are required to pay taxes in support of the church. Be it enacted by the government council and representatives in general court assembled, and it is enacted and ordained by the authority of the same, that every inhabitant in this colony shall henceforth contribute to the public charges in church, town, and colony, whereof he doth or may receive benefit. Now, those are the 17th century laws. So coming into 1700, you're required to attend church, you're required to pay taxes to support the church. And if you want a different church, you and all of your neighbors need to get permission from the general court. Things start to liberalize a little bit in the 18th century, but not as much as one would think. Here is the 1708 Act of Toleration. This follows up on an Act of Toleration passed in England and reads, "It is further enacted for the ease of such as soberly dissent from the way of worship and ministry established by the ancient laws of this government, and still continuing, that if any such persons shall at the county court of the county they belong to qualify themselves according to an act made in the first year of the late King William and Queen Mary, granting liberty of worship in a way separate from that which is by law established, they shall enjoy the same liberty and privilege in any place within this colony, without any let, hindrance, or molestation whatsoever." Please note, this didn't actually excuse them or release them from paying taxes, provided always that nothing herein shall be construed to the prejudice of the rights and privileges of the churches as by law established in this government, or to the excusing any person from paying any such minister or town dues as are now or shall hereafter be due from them. So think of it this way. The 1708 Act of Toleration allows you to worship in another church, but you still have to pay taxes. You still have to formally support the town minister. This is the 1784 Act for Securing the Rights of Conscience in matter, conscious being the consciousness or personal responsibility in matters of religion. Please note, this is the start of freedom and religion in Connecticut. However, there is a key word in this act. Act for Securing the Rights of Conscience, forgive me today, and matters of religion to Christians of every denomination in the state. This only applied to Christians. it did allow people to attend dissenting or non-congregational churches, and it also allowed them to direct their tax monies towards the support of their own church. This creates a unique record set, which gives us some leeway as genealogists. So what does this all mean in terms of records? Well, first of all, we have the records of the minister. The appointment of a minister, the idea of a minister, required the permission of the colonial assembly, but the choosing of the minister himself was generally carried out at the town level. So the assembly would say, this town is allowed to choose a minister. The town would go ahead and find that person. In the event of conflict, matters were actually brought back to the assembly on a regular basis. So records of the minister can be found both in the public records of the colony of Connecticut and in the town meeting records of that particular town. Here's an example. This is from Durham. At a town meeting, October the 4th, 1708, the town by a full vote did agree and desire the much esteemed Mr. Nathaniel Chauncey to settle with us in the office of pastor. At the same meeting, the town, by vote, did agree and grant the much esteemed Mr. Nathaniel Chauncey should have, and do by these presents grant unto the said Mr. Chauncey the house and all appurtenances thereunto belonging, and it continues to indicate that Nathaniel Chauncey was not only the appointed minister for Durham, he also received a house as part of this appointment. So the records of the minister can be found both in the town meeting records and in the records of the colonial government. What about records of the congregation? Well, dissent was not allowed in Connecticut at all until the Toleration Act of 1708, not fully allowed until 1784, and then notably only allowed among Christians. As a result, many Connecticut residents were Congregationalist by default. Church records in Connecticut, therefore, can serve as an alternate source for documenting birth, marriage, and death. The Connecticut State Library has somewhat of a unique resource. In the early 20th century, it collected church records from it throughout the state. In some cases, it maintained a copy and returned the original to the church. In other cases, they maintained the original and returned a copy. This collection does not include Catholic or Jewish records, but can include Baptist, Episcopal, Methodist, and other congregations. A list of church records collected, as well as images of the original books, can be accessed through Family Search. We also have, to make it even easier, an index. It does not index the full collection. It covers approximately 25%. But what it has been indexed also includes an abstract. Now that 25% of the church record collection is available in two forms. If you do Connecticut research, you probably have heard of the Barber collection. This collection was set up the same way. There is a slip index, which is available on Family Search, and there are bound volumes, which are available on Ancestry. This is an example from the slip index. We don't have this individual's full last name, but we know his first name was Stephen, and that he was admitted to the church at Branford on July 2nd, 1725. Now, if I wanted to go pull the original record, we'll find it on volume 1, page 4 of the records of the First Church of Branford. What about dissenters? We talked about the congregation. What about dissenters? A dissenter is anyone who chose not to attend the Congregational Church in Connecticut. There is no central record set for dissenters, but you may find them counted or listed among court records for skipping the required services, in town meeting records, where they were seeking exemption for the payment of congregational levies or payment of taxes towards the support of the Congregational Church, and in the records of their own churches. So, why does the established church matter? Church records can provide valuable evidence of birth, marriage, death, spousal relationships, and parent-child relationships. But these records are sometimes hard to find because the researcher doesn't know where to look. Knowing that an established church existed and where someone who was not a member was recorded can help guide a researcher's work, revealing valuable information about their family tree. Thank you so much for having me today. Be glad to answer any questions.